A report from the Insurance Bureau of Canada with law firm Dentons finds that a growing number of third-party investors is using the Canadian courts to profit from other people's lawsuits. And the trickle-down effect could be felt in people's companies' insurance premiums. It's a trend that has already emerged south of the border. We are joined by Vivian Hua, who is legal counsel at the Insurance Board of Canada. Vivian, thanks very much for coming on the show. So tell us what is meant by these third-party lawsuits. Give us an example of the kind of thing, please.
So third-party litigation funding involves a third party, usually a private equity firm, investing into a lawsuit. These lawsuits typically were, the design for this funding was originally to promote access to justice. It was intended to capture mostly individuals who are disenfranchised in the system and who needed resources in order to access justice. What we're seeing now and what's happened in the States is that firms are now taking on investments in exchange for a share of the proceeds. And so in the Dentons report, it's found that firms are offered anywhere between $20 to $100 million in exchange for 20% of the proceeds of the cut of the settlement. The issue with this is that it encourages people to seek greater damages. They know that they're going to lose a cut of their proceeds to this investor, and they still want the damages that they're entitled to. This also has resulted in a lot of claims that wouldn't necessarily make it to a court, ending up in court. And this is what's putting pressure on our commercial insurance market today.
That's interesting. So I'm a private equity firm. I have no interest in the lawsuit, but I just want to make money from a settlement.
Yes, that's correct. They charge exorbitant interest rates sometimes. And I think the issue with this is also it's very largely unregulated. So we have very little insight into how it's being used, into the terms around this. And so private equity firms, for the most part, get to sort of swing their weight around and with their money, and they get to have a lot of say in the contract negotiations.
That's interesting. Any kind of litigation is expensive. I suppose companies have to defend it. Even if they win, it's costly.
Exactly. Litigation is incredibly expensive. It's what drives claims pressures in Canada. So anything that increases the cost of doing litigation puts a pressure on insurance premiums. So things like the expanded use of litigation funding, but also other factors like increased legal advertising and also the rise of class actions, which are also trends that are noted by the Dentons report.
Yeah, that's interesting. So here's another angle. We have these law firms, ambulance chasers, I guess they get called sometimes, advertising heavily and using this as contributing to an inflation in legal costs, or it's at least making people more litigious.
Yes, correct. I think people are very familiar with the idea of economic inflation, but the idea of social inflation is a bit harder to wrap your head around. And it's the idea that social trends and behavior that make it expensive to do litigation increase the cost of claims, which makes it more expensive to buy your insurance policy, which makes it more expensive to do business. And historically, what that means is the consumer foots the bill for that.
It does. I mean, excessive litigation has a deadening effect on society, doesn't it? I mean, I think we've seen amateur sports associations warning about the prohibitive cost of insurance.
Yes, for sure. I think in the current market, we are seeing an expanse in terms of what types of litigation is being attracted. Our society is becoming more sophisticated, and the types of liabilities that exist are expanding. So things like 20, 40 years ago, we didn't have things like cybersecurity breaches and privacy concerns the way that we do now. And all of those things are expanding the exposures that businesses in Canada are faced with now. And it puts pressures because all of these businesses are seeing this increase in lawsuits, and it's quite damaging for businesses. The report also finds that I believe it was between 2020 and 2023, 70% of small Canadian businesses reported that they've engaged with at least one lawsuit, which suggests to us that there's an immense amount of pressure that these businesses are facing.
It's a lot of stress for if it's a one-person business or something, even apart from the cost. They've got to just get involved in dealing with this. What about judges? Are judges being more vigilant? Are they more inclined to throw out cases if they think that they're just money-chasing exercises?
So the difficulty with third-party funding is that it's often not disclosed. So it has to be disclosed in circumstances like class actions, and it has to be disclosed for bankruptcies. So in those cases, judges have a lot of oversight into those financing agreements, and they can ensure that lawyers' professional duties are being strictly adhered to. The issue is, for every other case, third-party funding is virtually unregulated. There's very little insight that judges can have into this, and that makes it very difficult for them to curtail the issues. So the paper actually calls for regulators to take action on this. We believe that regulatory change that restricts access to the funding to solely issues that promote access to justice, as opposed to speculative investment tools, for instance, would be a great first measure to curtail the impact of this. And it is more likely in the responsibilities in the wheelhouse of the regulator than it would be for the judges. But the report does find that there are some concerns. There is an important role for judges, more so in the States than in Canada.
Finally, BC. In BC, if you bring a lawsuit and you lose, you won't necessarily have costs awarded against you. But so it's different from the rest of Canada in that respect, and that may encourage more lawsuits?
Yes, and that's what the report found with class actions. So in BC, they have a very plaintiff-friendly framework. And what that means is in most jurisdictions in Canada, if you bring a lawsuit and you lose, you have to pay for the cost of that. The exception is BC has created a no-cost regime for plaintiffs, which means if the plaintiffs are unsuccessful in bringing a class action, they don't have to pay for the cost, which means that the defendant has to foot the bill, even if they were in the right and even if there is no valid claim against them. And we are seeing that this has already had an impact on how class actions are being filed in Canada. There's an increase in filings in BC, and there's a decrease in filings in provinces like Ontario, who recently had jurisprudence that made it more difficult to certify a class action. And because class actions impact people across the country, what you're seeing is, for these nationwide concerns, the complaints are being filed in BC because that's the easiest place to get done.